Yeah, if you could hold on a second, I gotta put in the microchip.
We're hoping to have Attorney Larson available with us by remote connection if that can get worked out.
I think your mic's on, Calvin,
Thank you.
next to your gavel platform on the left. You've got it, like, just to the direct left of your gavel platform.
Hi, Cece, this is Cody.
Covered up.
Chambers, and we can actually-
Thank you.
computers to turn on.
I hope you can hear me now.
Yes. And I have an attorney who is waiting to join remotely. Okay, that sounds good, thank you. Okay.
Cody, can we get started?
Yep, you can get started. I
All right. Appreciate
don't
your
know if
efforts.
he's on or not, so.
All right. I call this meeting of the Wausau Ethics Board to order, and we should probably call the roll, although we do have name tags up here. I don't know if everybody can see those. So would you like me to call the roll?
I can do that.
Okay, thank you, Cody.
Dexter,
Here.
Hostler,
Here.
DeVos,
Here.
Mason,
Here.
Kearns.
Here.
All right, we did get minutes in a board packet. Has everyone received and had an opportunity to look at the minutes of the last meeting that we held?
Yes.
Looks like we have. Is there a motion to approve the minutes?
So moved.
Thank you. Is there a second?
Second.
Thank you. Any discussion? Seeing none, we'll bring it to a vote. All in favor of approving the minutes, signify by raising your hand. It's unanimous. And then I want to note that I think our board works best when we can all be present for a meeting and we can all contribute. And at our April 3rd meeting, unfortunately, we were unable to get Brian Mason's participation on key parts of our agenda through no fault of Brian's. He had been unable to get all the responses to our investigative orders despite his best efforts, and he properly abstained from votes on those matters. Robin DeVos fortunately suggested that we have this meeting so that we can verify all members have the complete responses, and so we can get the benefit of Brian's thoughts and those of any other members who, after hearing Brian. First, I would like to verify that all members have received all responses submitted by the respondent, the city attorney, and the city clerk as a result of our orders for investigation. Did everyone get Attorney Larson's, from Attorney Larson, a single PDF titled Mayor's Submission consisting of 70 pages?
Yes, I have.
You've all
that.
received that?
Yes.
And it reflects the entirety, is my understanding, of the respondents' responses to our investigative orders. In fact, I checked that against what I had previously, so I'm confident that we have the entire combination of documents that were submitted by the respondent. Is there any member with concerns about whether they have received the responses to our orders that were submitted by the city attorney and the city clerk. Not as much material there, obviously. All right. Then, the next item on the agenda is discussion of and possible action on those responses that we have received, and, if necessary, possible reconsideration of the preliminary determination concerning probable cause adopted on April 3rd, 2025, and possible action thereon. Everyone had an opportunity now to review all of that material? Great. I note that the PDF we received from Attorney Larson has that page number feature, and I think it would be helpful in this discussion if we want to refer to a specific document that we note the page if we can as part of our comments. And if the board is ready now, I know we would all appreciate hearing Brian's comments after he's had an opportunity finally to review that material. Brian.
Yeah, I wrote my comments down to just be as succinct as possible. Thanks for scheduling this meeting, and I echo thanks, Robin, for the suggestion. So I really appreciated the responses. I'm just going to kind of read off this. And this is what I came away with. I continue to believe that we as the ethics board are operating without the full picture. When you read through all 5 of the documents that Attorney Larson forwarded to us, as we already discussed last time, both the city attorney and the city clerk have declined to provide sworn statements or release certain documents citing the ongoing DOJ investigation, and they also mentioned attorney-client privilege. Also, we discussed that last time. And I just want to be clear, I really respect those legal constraints, but this is where I come down. I think their absence from the records, especially in light of Attorney Larson's comments that, everything is sealed to this board, I think that the absence, I think it affects how complete our understanding can be. And I also think that it affects how transparent this process is to the public especially. So I also understand that we subpoenaed the city clerk and the city attorney to appear at the April 30 meeting. But insofar as we did that, I think being subpoenaed doesn't necessarily guarantee that we're going to get a full testimony. And so I think a few things come to mind for me. Is in the interest of, I guess, fairness and our preparation, I think it'd be helpful if we could invite them, meaning the city attorney and the city clerk, to clarify before the hearing whether they intend to offer a full testimony, or if they anticipate continuing to invoke privilege or declining to answer certain questions. And I think knowing now, it's going to help us structure a better hearing and avoid any last-minute surprises. I have one more three-sentence paragraph, and then I'm going to conclude my remarks probably in less than 3 minutes. I also think it would strengthen the transparency if we invited the city attorney and the city clerk to submit a general summary of what categories of materials or statements are being withheld and why. This would not be a challenge to their discretion. I think it would be a good faith step forward, clarifying the scope of the record for us as the board and for the public. And I think we don't necessarily need detailed lists if they don't want to submit the full scope and they want to continue to invoke the investigation attorney-client privilege. But I think just a brief description of what's available and why would be very helpful for me as a board member. I also think that these steps, because we're discussing them today, won't delay the hearing, nor would it necessarily have to undo the board's decision to move forward. I voted to move forward. I think moving forward lets us continue to engage the information we have and we don't have to further engage the information we have and don't have. Sorry, the sort of weird statement there. I think that this will help us proceed with greater clarity, and it'll reinforce the public's trust that we are taking this matter really, really thoughtfully, that we're pressing to the furthest limits that we can reasonably get the information, and also that we are really, really committed to due process. That's what I came away with, and I don't trust anybody on this. I've worked with some of you for 5 years to really good effect. I just want to say that. And so I know that we're all committed to transparency. I know we're committed to the public. And I just want to be as transparent as possible as a board member about exactly what is missing and what's legally constrained. That's my takeaway. Thanks for letting me offer that.
Sure. Thank you, Brian.
Thank you, Brian.
Other comments from other board members on
Right.
on this?
I mean, I've thought about that, but I thought also that at a hearing, you can ask questions. There may be certain things that can't be answered, but there may be questions you have that aren't answered that can be answered. I mean, that's the other thing I think to look at. Don't feel it because they can't talk about certain things. They won't be able to answer questions you have that are fairly specific. So I think the idea, yes, well, no, they can still invoke that, and that's kind of a hardship. But on the other hand, there's still this question of, I might have for, say, the city attorney, I might have for the clerk, I might have certain questions that they can answer. So I wouldn't get too, I mean, I am kind of with you. It's too bad we're in this situation.
I think to Brian's point as well, the volume, just knowing the volume of the evidence that can't be provided might be beneficial to us if it's a single email, because we have no description as to how much information is being withheld due to the conflict with the case. So that may be beneficial even just if we're not able to get direct details about what's in that information. So I support that.
I look at it just a little bit with a different lens as to how difficult it is to ask these kind of hypothetical questions when we don't know the questions yet. So example, sort of what Doug said, there might be a specific question that they can answer, but it's difficult now to know those specific questions that will be asked during the investigation. So it's a little bit difficult to say, hey, are you still invoking this privilege when we don't know the questions that we are going to ask that they'll invoke the privilege for. So it's a little bit more of a difficulty in trying to figure out the scope of the
We can still hear you.
scope of the question. I don't know what's happening.
Getting replaced next week.
Okay.
I don't know if I was understanding you precisely, Doug, but it sounded to me kind of like you were saying some things that have been on my mind, and that is we get our answers on what they can or cannot tell us if they are subpoenaed, those two officers, and they will be on the stand under oath. At that point, we will find out, I think, what they can and cannot
Yeah. What they can and
talk
cannot do,
about.
yeah.
I mean, I would love to know how much is actually out there. It would be great to know what's not being provided to us, but I don't think that we're going to get that. So then that becomes the question. The question then becomes, can we act based on the limited information we have? I mean, it's possible there won't be sufficient evidence or information.
And I doubt too that they'll be able to give us the why, which would indicate a lot more about the documents that they're withholding. So I don't know that we're going to get the why, but as much as we, again, would like to have it.
Well, I think we'll get at least some why. I think, for one thing, the city attorney has the city, including the mayor, for a client, and she may be constrained from answering certain questions as a result of that position. And I don't know if there's going to be anything. I mean, what was shown in her response for the investigation was a letter dealing with one particular request to release a record, and that was about it. Now, we can ask her questions that don't relate to, don't require the city attorney to release that particular record or any particular records. They just ask for an answer to a question. So it's possible we might get some additional information because of that, but we don't know, I guess, until we ask. And what Brian seems to be suggesting is that we should ask before the hearing. I'm not real sure exactly what that will do for us that we can't get done at the hearing. Can you speak a little bit about that, Brian?
I guess the hypothetical in my mind would be at the hearing, and we ask questions, and the answers to the questions are, we invoke this privilege. We cite the DOJ's investigation, and we've submitted on the record what we're prepared, that's what we're prepared to say.
And if we can find out what those limitations are, we may be able to be more surgical with our questions as well to try to avoid those hot topics and also get more information that's within the bounds.
I think that's, to me, it seems reasonable because at this point, what the city attorney has submitted and what the city clerk has submitted is very, very limited to discuss. And the city attorney submitted, in essence, a PDF, I think probably just copy and pasted from some website about, talking about the city clerk and ballot boxes. It's just very, very limited. It's hard to know what we're going to be able to actually discuss. And furthermore, moving forward, I think it invites an element of curiosity for me about what we're moving forward with.
Was that document, sorry to drill in a little bit, but was that document sent to us as something that the attorney was sending to us, or was that a document that she had passed along? Because I interpreted that as a document that she had sent to others in the process of this, as this has gone on.
It's unclear to me because I can't tell if she's saying, because in the email, I didn't print the whole packet, so I can't cite page numbers. But she says, in essence, as previously instructed to the mayor and the clerk. And then there's this information about drop boxes afterwards. And so to me, it's sort of saying, okay, well, was that included in an email? Was that part of a discussion? Is that just for our interests to know that that's what she based her referenced comments on?
Well, I wanted to get some clarity on what we're actually talking about. And the city attorney's response includes her official opinion, which was released before that Department of Justice investigation started. So it was already public.
Right.
And my understanding is that her opinion wasn't based on those attachments, but the attachments were relevant. They were additional material on the subject. Did anybody else see that differently?
That was my interpretation, was that
Yeah.
this was more of her kind of referencing where she pulled her perspective from. Not so much even an argument, just saying that if she was being asked, where did this information come from, that's where what she provided was the source of that information. And
Yeah.
in relevant case, so to speak, with, I think it was Milwaukee.
Well, I think what was there was that official opinion, and then additional material was attached to it as being seen as relevant and helpful. I don't think that the city attorney based her opinion necessarily on those two attachments. One was from the Wisconsin Elections Commission, dealt with guidance on absentee ballot drop boxes, and a similar publication came from the United States Election Commission. So as I read it, they weren't the legal basis for her opinion. The Priorities USA case was the legal basis for her opinion. So anyway, I hope that clarified things for me to talk about that a little bit.
Right. And there is that section, I forget which one it is, Exhibit C, is where conversations were included among different people, and there was a fair amount of Caitlin in there, of the city clerk in there. Because there were things that she had written and written back and responded, and that was actually very helpful to me.
Right, and I
So
think
there was,
that's,
so there is much more than just what she said herself.
I think that maybe relates to the material that the respondent provided, because the respondent
Right.
provided a great deal of
That was
material.
good, yeah, that was very
Yeah,
good.
I found it
Very
helpful.
So I was very happy with that, yeah.
I'm wondering, Brian, are you hoping that we will take some action? Are you interested in making a motion, or?
Yeah, I think I'll make the motion that we invite both the city attorney and the city clerk, to the best of their abilities, to clarify whether they intend to offer full testimony or if they anticipate invoking privilege or declining to answer certain questions. In the same motion, I would like to invite the city attorney and city clerk to submit a general summary of what categories of materials or statements are being withheld and why. I just want to be, that's the end of my motion. And I just want to say just one clarifying thing. I think just a brief description of what's available and why is helpful. It would certainly be helpful to me to be able to move forward and to engage the information, and also, as we've already discussed, to anticipate the most productive way to engage them, understanding that it is, to Robin's point, exceptionally difficult to predict a conversation, but nevertheless, thus far we've received very limited information. I've given my motion.
I'll second the motion. Do you have that in writing?
Yeah,
Good.
well, I have it in writing across 2 places. I can underline it.
Can you hear me?
Yeah.
Eric?
Ooh, oh.
Yes.
Oh, good.
Maybe when you underline what it is that in writing that's you can then repeat it so that we have a clear statement of what that motion is.
Do you want me to repeat the motion now?
If you're ready.
Yeah, I'm ready.
Yes, please.
I motion that we invite the city attorney and the city clerk to clarify before the hearing whether they intend to offer full testimony or if they anticipate invoking privilege or declining to answer certain questions. And to invite the city attorney and city clerk to submit a general summary of what categories of materials or statements are being withheld and the reasons why.
Thank you, Brian. It's been moved and seconded. Is there discussion, further discussion?
Yeah, once again, that I find it a hard motion to deal with because you're asking to predict what they're going to do or not do, which I think we already know. I mean, it just doesn't seem helpful to me. It's not something, it apparently helps you, but it doesn't help me. I figure when they get here, they will do what they have to do and not do what they can't do.
I
don't
would.
know why am I asking ahead of time, and why am I asking to describe the areas, which might be very difficult? I mean, if I were in their position, I would say, I cannot give you anything that relates to the things I'm not allowed to speak of in relation to this investigation. What does that tell you? Nothing. I mean, you kind of know there's an area it's not going to work. So I don't think the motion is necessary.
I mean, you can correct me if I'm wrong, Brian, but I think you're trying to figure out where that boundary resides to a little bit better degree than we have currently. And I think we may want to be even more specific in our ask. We may want to ask for like what medium. So like, are these emails between you and the mayor? Are these, because I mean, if they're documents like we've seen where it's like, if they're sending along an idea about where something comes from as a source material, that may be relevant to understand, but it's more important, I guess, that we understand like correspondence, right? So if these are correspondence between you and the individual that's under the complaint, that would be relevant. So we may want to even ask for like what type of media was shared, because if it's personal and back and forth messaging, that does, obviously if it's out of bounds, it's out of bounds, but we would at least understand where this evidence would be missing from.
Am I sensing an amendment to the motion?
I don't know that we need an amendment. I think it's a clarifying statement. I think it's probably covered in Brian's commentary. If we're asking for the types of communication, I'm just hopeful that they interpret that the way we're intending.
To me, I mean, I tend to, in a lot of ways, I agree with Doug that we'll find out when they get here. But Brian's motion is inviting them to provide us with that kind of information. And I think it could be helpful to get it. I think it could have an effect on the kinds of questions we might ask. I don't really see any harm to it, as long as it's not delaying our proceedings. And if we can get a letter out, I think within the next couple of days, there's a possibility we'll get an answer, and it might be helpful to us.
Well, and without this information, that may be a delaying part of the process, because if we're not able to ask questions, is there a reason to have a secondary hearing? So it might actually help us get through the process more cleanly.
Yeah, maybe, although I think, they're subpoenaed, they're under oath, they will tell us what they can tell us, they won't tell us what they're not going to be able to tell us, and I don't know that would necessarily cause a delay, but I think it could be helpful to have this. And if we get a prompt response from them, I think it'd be great.
I feel very similar to Calvin, and I'm not sure we're going to get anything from it. But I don't mind. I like how you phrased it, Brian, with the invitation, and that's where I think maybe it doesn't harm. I'm not sure if it's going to help, but it doesn't harm. So I still think my first statement is very true. It's going to be very hard for them maybe to answer those questions because they don't know what kind of questions are going to be asked. However, since it's an invitation, I don't disagree with it.
Any other discussion on the motion? Seeing none, we'll call it to a vote. All those in favor of Brian's motion, and if anybody wants it read again, now, please raise your hand. All right. All those in favor of the motion, raise your hand.
Okay?
Opposed?
Me?
We have one voting against and 4 in favor. Then, the next item on the agenda is discussion and possible action on procedures for a hearing.
All right, that's a good one.
The ethics code says little about the procedure to be used
Right.
in conducting the hearing, other than that the due process rights of the respondent, the burden of proof, and the applicability of chapters 901 through 911 of the Wisconsin statutes to the admission of evidence, those are mentioned in that code provision.
Okay.
I recommend that members review again, if you've already reviewed them, I'm sure you have, section 2.03.080 of the ethics code, and also review the state statutes on evidence, those chapters of the state statutes. If anyone has difficulty finding them, I mean, you can do a Google search for the Wisconsin statutes table of contents. That'll probably get you where you need to find those particular chapters, just to get some kind of familiarity with what they say and get some idea of how they work.
What was the, what was the reference to the 2.03? What was that again?
Oh, that's the,
2.03, just the numbers.
that's from the Ethics Code,
Right.
2.03.080,
Right, thank you. That's it.
dealing with the hearing.
That's why I
Yeah.
want to make sure I had the numbers right.
Good, good.
Thank you.
Attorney Larson and I have had some preliminary discussions about matters such as questioning witnesses and handling objections. I plan to continue those discussions with him, and I would like to have a proposed procedure, how things are going to work for the hearing for you to consider at the beginning of our meeting on April 30th. I don't know if either Attorney Larson or any of the members have any specific questions or concerns or things that they want to talk about at this time.
Will it be our attorney primarily asking questions? Is that already started to be discussed? And then with an opportunity for each committee member? I think we should be prepared to ask those questions if we have an opportunity to ask questions.
Yes, we have talked about having a single person and having the primary examination, and then if there are board members who have specific follow-up questions or questions that haven't been addressed, they would have an opportunity to.
Thank you.
Would we then want to submit questions that we might have as individual board members to Attorney Larson beforehand? Or is that something we want to kind of, obviously things will come up throughout the hearing, but if we have questions kind of on the correspondence that are maybe not going to come up organically, do you want us to share those, or is there going to be a point where we can actually ask those questions during the hearing?
I think there would be a point during the hearing where you would have an opportunity to ask those questions, yeah.
So, just a couple thoughts, Mr. Chairman. First, from the big picture, our code requires you to follow rules of evidence. It certainly is a quasi-judicial setting. I think because of that, we're going to structure this a lot like a court proceeding. We will begin with witnesses, which presumably would be the complainants, or the complainant's witnesses. Each witness can be asked questions, like cross-examination. It's not as formal as a court necessarily, but it's pretty formal because we're expected to follow the rules of evidence. What I suggested to Calvin in our conversations was the following in terms of how the board is going to ask questions. My suggestion is that as chair, Calvin should take the first crack at asking questions, and because he might hit on questions that the other board members have. If there's something he didn't ask that other board members want to ask, there should be an opportunity for the other board members then to be recognized to ask what they think is appropriate. So as far as the board asking questions, that's the way I did suggest it. And there may be cross-examination from the respondent of the complainant's side of the case. Then there will be an opportunity for the respondent to provide witnesses and testimony, and the same kind of a process would be followed. We may receive objections to the evidence as it's received, just like in a court. My suggestion is that the chair would rule on those objections. He's free to consult with me as appropriate if he wants to. But he would issue the ruling on those objections. If anyone on the board, he would, a unanimous consent kind of an approach. So the chair is going to rule on the objection. It's going to be presumed to be a unanimous consent unless anyone on the board takes a different view. You just need to express that, in which case the ruling on the objection would be made by a motion. Somebody would make a motion, I rule that we overrule the objection, or we sustain the objection. That would need to be seconded, could be discussed and adopted. That's the process from 10,000 feet that I picture.
Thank you, Attorney Larson. Any board members have any thoughts on the matter at this point?
I'll just want that repeated again.
Oh, yeah, I think that'd be a good idea, right?
Yeah. Because my memory is not the best.
All right,
That's
well, let's see. Looking at the time. The next item on the agenda is adjournment.
Yeah,
Is there a motion to adjourn?
why so moved?
It's been moved. Is there a second?
Second.
Moved and seconded. All in favor of adjourning, signify by raising your hand.
But one of them,
It's unanimous. We are adjourned. Thank you.
thank you very much. Yay.
I know, these are really good.